Welcome to the deep dive. Today we're really getting into a cornerstone of South African civil society. We're talking about the Nonprofit Organizations Act of 1997.
That's right. It's fundamental for understanding how NPOs operate legally in the country.
Absolutely. And this isn't just a look back in 97. Our mission here is to unpack the whole consolidated law, its framework, sure, but critically the significant updates. We're talking Act 22 of 2022, which really kicked in late 2022 and early 2023. Big changes.
Huge changes, especially around who has to register and who's allowed to be in charge.
Okay, so let's start at the beginning then. What's the core idea behind this act? Is it trying to help NTOs or, control them?
Well, it's definitely both. That's kind of the central point, really. Section 2 lays it out. The goal is to foster an environment where NPOs can, thrive, do their work, but, and this is the key part, that support comes with strings attached. It sets up a pretty robust administrative and regulatory framework.
To ensure standards are met?
Exactly. Governance, transparency, accountability, those are the watchwords. And just for context, this act replaced parts of the old, slightly messy Fundraising Act from 1978. It aimed for clarity. And defining an NPO is step one. A trust, company, or association set up for a public purpose.
Public purpose being the key phrase there.
Right. And crucially, its money and property can't be distributed to members or office bearers. The only exception is reasonable pay for actual services rendered. If profits go private, legally, it's not an NPO under this act anymore.
Got it. That line is clear. So let's talk about the support side first. Chapter 2, the state's role. Section 3 says the state must promote, support, and enhance the capacity of NPOs. That sounds quite active, not just passive regulation.
It is. It's a directive. And to make that happen, the Act established the Directorate for Nonprofit Organizations. The Directorate sits within the National Department handling social development or welfare.
And what does the Directorate actually do? Is it just registration?
Oh, much more. Section 5 details its functions. Yes, registration support is there, helping NPOs get through the process, but it also facilitates policy development, runs support programs, and actively works on upholding governance standards.
Interesting.
And here's something quite forward-thinking for 97 Section 5.2, allows the Directorate to create memoranda of understanding with other state bodies. Think information sharing, maybe even delegating some admin functions. It's about trying to get government departments on the same page regarding NPOs.
And I saw something about model documents, standardizing things.
Yes,
Right.
Section 6. The Directorate provides templates like model constitutions, guidance on narrative reports that helps NPOs. But interestingly, it also mandates codes of good practice for those giving money donors, grant makers. It's trying to shape the whole ecosystem's behavior.
Okay, so that's the supportive framework. Now, the requirements. What does an NPO actually have to do to get registered?
Right, this is where we see those 2023 updates really bite. Section 12 sets out two main categories for registration. First, there are NPOs that may apply. This covers most domestic NPOs. Registration is optional for them, though often beneficial.
Okay, the voluntary route.
But then there's the second category, NPOs that must apply, mandatory registration. And this mandatory part, Section 12(1)(b), was significantly broadened. It now specifically targets NPOs with international links.
How so?
If your NPO makes donations to anyone, individuals, or organizations outside South Africa, you must register. Or, if you provide services, humanitarian, charitable, religious, educational, cultural, outside the Republic's borders, again, registration is mandatory.
Wow, okay, so any cross-border activity automatically triggers mandatory registration now.
Essentially, yes.
Yeah.
It's a clear signal of increased scrutiny over international financial flows and activities within the NPO sector.
That definitely links NPOs to wider global regulatory concerns. But whether it's voluntary or mandatory, Section 12(2) lays down some strict rules for the NPO's constitution, right? What are those?
Absolutely non-negotiable points. First, the Constitution must explicitly state the NPO is a body corporate. This means it's a separate legal entity from its members or leaders, protects individuals, but makes the organization itself accountable.
Makes sense. What else?
Second, that non-distribution constraint we mentioned, no private profit. Third, financials must go through a proper banking account, essential for transparency and auditing. You can't just use a personal account.
And the final point deals with what happens if the NPO closes down.
Yes, the dissolution clause. If the NPO winds up, after settling debts, any leftover assets must be transferred to another registered NPO that has similar objectives. It's a lockbox. The funds stay dedicated to a public purpose. They can't leak out even at the very end.
That's a comprehensive set of safeguards. Practically speaking, if someone applies and their constitution isn't quite right,
The director gives them a chance. They issue a notice, you get about a month to fix the issues. If it all checks out, you get your certificate of registration. And Section 16 clarifies that this certificate is the official proof that the MPO is recognized as a body corporate.
Okay, so you're registered. Now, how do you stay compliant? Let's talk accountability. Sections 17 and 18. This sounds like where the regulation really shows its teeth.
It does. Section 17 is all about financial accountability. NPOs need proper accounting records following standard practices. They have to prepare annual financial statements within 6 months of their financial year end. Pretty standard stuff so far.
But there's a check on that, right? An accounting officer.
Yes, that's the crucial bit. Within 2 months of drafting those statements, they need a written report from an accounting officer. This officer confirms 2 things: that the statements match the accounting records, and, importantly, that the NPO has followed the financial rules set out in the Act and its own constitution. It's an independent verification step.
So the numbers are checked. What about the bigger picture, the activities? That's Section 18.
Correct. Section 18 is the duty to provide information. Annually, within 9 months of year-end, MPOs must submit a narrative report detailing their activities. They also submit the financial statements and that accounting officer's report we just discussed.
Okay, but you mentioned the 2023 updates added something significant here.
Hugely significant. A new subsection, 18(1)BA, was inserted. It requires NPOs to provide prescribed information about their office bearers, control structure, governance, management, and operations. It's much more detailed than before, but the real kicker is subsection 18(1)A.
Which says?
It says that these new detailed information requirements must be prescribed after consultation with the Minister of Finance and the Financial Intelligence Center, the FIC.
Wait, the FIC, can you just quickly explain for listeners who might not know, what is the FIC and why is their involvement here such a big deal?
Sure. The FIC, the Financial Intelligence Center, is South Africa's main agency for combating money laundering and the financing of terrorism. AML-CFT, as it's known. Bringing them into the NPO Act consultation process sends a massive signal. It explicitly links NPO regulation to national financial security and efforts to fight financial crime.
So the government is basically saying NPOs could potentially be misused for illicit financial activities, and this act is now a tool to prevent that.
That's exactly the implication. It aligns NPO oversight with global financial integrity standards, like those set by the Financial Action Task Force, FATF.
Right, that really elevates the stakes for compliance. So what happens if an NPO doesn't comply, if they miss deadlines or submit false info?
The process starts with a compliance notice from the director, usually giving a month's grace to get things in order. But if they fail to comply after that, or crucially, if they're found to have made materially false representations in any reports or applications,
Then what?
then the director can cancel their registration. Section 21 is blunt. Cancellation means an immediate stop to all rights, benefits, and allowances that came with registration. This is a serious consequence.
But there's a way to challenge that, an appeal.
Yes, there is. Decisions about refusing registration initially or later canceling it can be appealed. The Act provides for an arbitration tribunal to hear these appeals, so there is a recourse mechanism.
Okay. Now, arguably the most impactful update, Chapter 3A, Section 25A, disqualifying and removing office bearers. This seems like a very direct move to ensure integrity at the top.
It's incredibly direct and very targeted. It's about preventing individuals who pose a risk from controlling these organizations. Section 25A1 lists specific grounds for disqualification. It's quite a list.
Let's go through some key ones. What kind of things disqualify someone?
Okay, well, firstly, financial unreliability. Being an unrehabilitated insolvent disqualifies you. Also, if you've been declared a delinquent director under the Companies Act, or Close Corporations Act, basically, if you messed up badly running a company before.
So past corporate governance failures matter. What else?
Integrity breaches. If you've been removed from any position of trust due to misconduct involving dishonesty, and then there's the direct link to serious crime, especially financial crime.
Such as?
Conviction and imprisonment, or a significant fine for offenses like theft, fraud, forgery, perjury, but also specifically listed money laundering, terrorist financing, or proliferation financing activities. These terms come straight from the FAC Act. Being subject to UN Security Council financial sanctions also disqualifies you, and simply being an unemancipated minor.
That's a powerful list. It really puts NPO leadership under a microscope, similar to, say, directors of banks. What's the immediate effect if someone falls into one of these categories?
The effect is immediate, according to Section 25A2 and 11. A disqualified person cannot be appointed, period. And if an existing office bearer becomes disqualified, say, through a conviction, they immediately cease to be entitled to hold that position, They're out.
And how is this enforced or monitored?
Transparency is key here. Section 25A9 mandates the Directorate to set up and maintain a public register of all disqualified persons. So NPOs can check, and the public can see who is barred from leadership roles. It makes it much harder for disqualified individuals to slip through the cracks.
A public register. That's a very strong statement. And the Act backs this up with penalties, too.
Yes, Section 29 and 30 create offenses. Making material false representations is a crime. Failing to comply with these new governance information requirements is also an offense, potentially leading to fines or even imprisonment.
Okay, let's wrap this up. We've covered a lot of ground on the NPO Act. It seems to be, as you said, a real balancing act. On one hand, Chapter 2 offers support, structure, legal recognition. On the other, Chapters 3 and especially the new 3A demand really high standards of accountability.
Precisely. Particularly around money and leadership integrity. And connecting it to the bigger picture, the recent changes tying the Act explicitly to the FIC, focusing on international activity and these strict disqualifications, it shows South Africa bringing its NPO sector regulation firmly into line with global efforts against money laundering and terrorist financing. NPOs are now seen as part of that defense infrastructure.
So, for you, the listener, what's the takeaway? If you're involved with an NPO, studying law, or just interested in civil society, the message seems clear. Being a registered NPO brings benefits, yes, but it comes with serious responsibilities. Governance, transparency, who leads the organization, and any international links, these are under intense scrutiny now.
The bar has definitely been raised.
Absolutely. So, here's a final thought to leave you with. The Act clearly states the government has a duty to promote and enhance NPOs. Section 11 even allows the minister to prescribe benefits or allowances to encourage registration. We've seen the regulatory stick strengthen significantly. What might the carrot look like in the future? Beyond existing tax breaks, what new incentives or support programs could the minister introduce to genuinely help NPOs flourish in this demanding new landscape? Something to think about.